Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In my previous videos, on one occasion I told you that it is the statutory duty of the police department under 154 crpc to register a case of a cognizable offense. When once they register a case, then investigation is in their hands. The goal of the investigation is to find out the truth, but investigation they can do in different ways and they can come to different conclusions. Of course, it is within their domain. Investigation is their job, but the investigation should not be perfunctory. It should be clear. It should reach the goal. Otherwise, if it is investigation is perfunctory or biased or investigation is not done on sound lines, the court is there to punish the concerned police officer. Same thing happened here in Allahabad High Court. So, in the case of X, she is a victim of rape. X versus State of UP and 6 others. In criminal miscellaneous writ petition number 13325 by 2022, dated 7th December 2022, two judges bench, Justice Sumit Kumar and Syed Wais Mia. They noted that the investigating officer or the police officer, so he assumed or he adorned himself the role of the IO as well as the court, and he deleted some of the accused from the array of the accused. That means at the time of filing charge sheet, he has deleted the name of R6 and R7 or A6 and A7, for example. So actually, who are the friends of the main culprit? If you know the case in brief, then it will be better for you to know as to what happened. So actually, this is a case of kidnap of a minor girl who is below 18 years, subjected to her rape, and taking a video of the incident and actually informing her husband and spreading it through video. So all the sections have come. So here it refers to crime number 359 by 2022 under sections 363 kidnapping, 376D gang rape, then 504 and 506 of the APC criminal intimidation, as well as section 3 and 4 of the POcso Act, that is Prevention of Children from Sexual Offences Act 2012, as well as section 67 of the Information Technology Act, where they have published the sexually explicit matter to the social media. So this relates to of some PS. Sadabad PS of Hathras district in UP. You may be knowing whenever the word Hathras, immediately you will remember that Hathras rape victim case. Very bad case. But anyway, this is a different case, crime number 359 by 2022. So that means in this case, the allegation actually, the girl filed a private complaint. Private complaint means 156 clause 3. She filed a private complaint before the court, alleging so-called the accused person along with his two friends kidnapped her. So enticed her to an isolated room or to a specific room for this purpose, then outraged her modesty. When she fell unconscious, that means she was given some sedative, and then after committing the so-called sexual assault, they made a video clipping. That is only 1 minute video clipping of the incident. Then the accused threatened her, continued the threats also. Why? Because he threatened her to have physical relationship, lest he will upload the same in the social media. Ultimately, so due to the threat she has to maintain the so-called physical relationship, and actually he coerced her. Even after marriage also, he wanted to have the relationship, and when she refused, this fellow has sent the so-called video clipping to her husband, due to which the family life was distorted. Ultimately, she has given a complaint. So this is the case. In this case, the IO has taken up the matter for investigation. In this, another important point I want to tell you. And after registering the case, the IO sent her to the judicial magistrate for getting her statement recorded under 164 CRPC. In 164 also, she categorically narrated as to what happened. That means the so-called A1 victim and his two friends enticed her to the room. Then they given some sedative. They enjoyed her like that. All these things were there. But the video has come surfaced. The police, as a part of their investigation, they have taken a copy of the video. The IO has eliminated A6 and A7, who are friends of the so-called main culprit. The reason is that they were not found in the video. That means she has falsely attributed their involvement also. This is the thing. So, when you go to the POcso Act, please remember section 29 and 30, they are more important. Whenever any woman, any girl here says that she was subjected to so-called sexual assault without her consent, the presumption is that they have committed sexual assault on her. So now it is the burden of proof which is lying on the other side, not on the woman. They have to say that they were not they were not involved in this offense. But here, basing on the 164 statement itself is sufficient. There is 161 CRPC, that is, IO has recorded definitely her statement. She stated all these facts. In her 164 statement also, she stated the involvement of A6 and A7. But this gentleman, the IO, has deleted their names right from the array of the charge sheet. Of course, you know, when the charge sheet comes before the court, so under section 173 clause 2 CRPC, the court has to send a notice to the victim stating that so-and-so IO has deleted the names of so-and-so accused. Have you got any objection? సో ఇది చాలా గుర్తు పెట్టుకోండి. మనం చార్జ్ షీట్లో పోలీస్ అధికారి తీసేసినంత మాత్రం కుదరదు. అక్కడ నోటీస్ ఇస్తారు జడ్జి గారు. నోటీస్ ఇచ్చిన తర్వాత ఇఫ్ యూ రైజ్ అబ్జెక్షన్, నో డౌట్ ఇక్కడ ఏమైంది, జిల్లా కోర్టు, సెషన్స్ కోర్టు హ్యాజ్ నాట్ అగ్రీడ్ విత్ ది అబ్జెక్షన్, పోలీస్ ఇన్వెస్టిగేషన్ 100% కరెక్ట్ అని చెప్పి తీసవతల పడేశారు. ఎస్, కోర్ట్ కెన్ డూ దట్. Ultimately, the matter has come to the High Court as a criminal miscellaneous writ petition, where the High Court was perplexed to see that the IO adorned the role of the police as well as the court. Who has to decide when there is 164 statement, when there is 161 statement, when there is medical evidence, when there is a complaint, when there is all these things? Normally, he should have completed the investigation and filed the charge sheet against all the accused. And since he has deleted the names of two other persons, the court is of opinion that either he has no knowledge about the investigation or he might have deleted purposefully for vexatious reasons or for this thing, ting. That's all. More than that we can say. Yes. So therefore, the court directed, Allahabad High Court directed that investigation of such sensitive and serious offences should not be entrusted to the particular IO. And the DGP has to initiate disciplinary or departmental action and immediately. And till such time, he should not be interested in the investigation of such similar cases. Anyway, this is a blot or serious. Adi matsa daryapta adhikari మీద. సో ఇంత మాత్రాన పోలీస్ శాఖ రియాక్ట్ అవుతుందా అంటే కొన్ని సందర్భాల్లో కష్టంగా ఉంటుంది. వీ హ్యావ్ సీన్ సచ్ కేసెస్ వే బ్యాక్ ఇన్ మేబీ ఇన్ 1981 ఆర్ సో. ఒక ఏడీజే గారు ఒక విట్నెస్ని ఇలా పెడితే మురళీ గారు, ఐఓ గారు చనిపోయారు ఆయన. సో ఐఓ గారు యాస్ ప్లాంటెడ్ సమ్ విట్నెసెస్ ఆయన ఇంట్లో వాళ్ళనే పెట్టాడు. పెట్టిన తర్వాత జడ్జి గారు కూడా కడపవటం వల్ల ఈ కుడ్ ఐడెంటిఫై దట్ దే ఆర్ ఫ్రమ్ దట్ పర్టికులర్ ప్లేస్, దే ఆర్ హ్యావ్ నాట్ సీన్ ది. సో ఆయన క్రాస్ ఎగ్జామినేషన్లో బయటపడిపోయింది. అప్పుడు కూడా ఇలాగే రాశారు, he should not be interested in the investigation of such serious case. ఆయన తర్వాత సిఐఏ డిఏ బోర్డ్ అని ఇన్వెస్టిగేషన్ చేశాడు. బట్ ఎనీవే కొన్ని సందర్భాల్లో కోర్టు సీరియస్గా తీసుకుంటే he should not be interested in the investigation. ఎనీవే ఇట్స్ ఎ ప్లాట్, ఇలా జరుగుతూ ఉంటాయి. సో ఇప్పుడు కోర్టు ఇష్యూని కన్సర్న్ డీజీపీ గారు కానీ పోలీస్ గారు సీరియస్గా తీసుకుంటే he will not be interested in the investigation. సో వెరీ సీరియస్ ఇష్యూ. మరి పోలీసు ఉన్నది దేనికి? ద మెయిన్ పర్పస్ ఈజ్ to maintain law and order, to prevent nuisances, and please remember to register case and investigate the same. If he fails to investigate, if he is not IO, appointed as IO, then it's definitely a blot on his character, on his conduct, or on his career also. So the police officers must be very, very careful, very, very sensitive to such particular offences. For that purpose only, I made this video. So please give careful while dealing with the investigation. And as advocates, we can cite such cases if the names of certain accused are deleted. With this, I am concluding. So please read the case law. X victim versus State of UP and 6 others. If you file the WPN number 13325, you will get the case law. Please read the case law and enrich your legal knowledge. With this, I am concluding. I will see you in the next video. Tata, bye bye.